So welcome everyone. Can everybody hear me? It's clear? Okay. So welcome everyone and thanks Clarissa for this wonderful introduction. It's always a pleasure to work with you and your colleagues around the world. So today I'll be talking to you about intellectual property, how it's protected in Canada. And also we'll do a twist on women entrepreneurship and some women that were successful in protecting their IP, so how they became famous and rich because of their IP. So, and thank you. So, as Clarissa said, ask your questions. I'll try to answer them as I see them, or I'll answer them at the end. We'll see what's easier. So what we'll do is I'll explain you what CIPO is. CIPO refers to the Canadian Intellectual Property Office. We'll go over some successful women entrepreneurs. I'll explain you why IP is important to you for your business to help it grow or to start your business even. Some tips when applying for IP, developing an IP strategy, and some IP resources also. First, I'll start with a quote from our Right Honorable Justin Trudeau, our Prime Minister of Canada. And I really like that quote because it speaks volumes. So everyone benefits when women have the resources they need to participate fully in our economies and societies. Our government is determined to help women gain the tools they need to be successful entrepreneurs and leaders. So just a bit of background. CIPO, the Canadian Intellectual Property Office, is an agency from our Department Innovation, Science and Economic Development, formerly known as Industry Canada. And last week they developed an innovation and skills plan that aims at supporting Canadian innovators to accelerate innovation through superclusters. We announced the development of 5 superclusters across Canada, including artificial intelligence, supply chain. The rest escapes me, but they're based on strength of Canadian economy. We also one of the goals is to support innovation in key growth industries in Canada. And of course, we like to help women entrepreneurs grow their businesses. So the main mandate of CIPO is to grant intellectual property rights. So we will register trademarks and copyrights. We will also grant patents and industrial designs, and we'll see later what those rights include in terms of protection. We also have 2 what I call tribunals. One is the Trademark Opposition Board and one is the Patent Appeal Board. So if someone, Canadian or foreign applicants or potential applicants, feel that some rights were granted wrongfully, they can complain and they can go to appeal, which is very important, and CIPO renders a decision on that. It can also escalate to higher courts, but most of the time it stays with CIPO. And in blue, what you see on that page is where I come from, is what we call the business service branch. And our mandate is to raise awareness and educate people on importance of IP and how to effectively use it. So what we do sessions like this. We can do also more tailored presentation on specific industries. We attend trade shows. And I meet people one-on-one. I know for you guys around the world it may be more difficult to meet with me, but an email is always welcome and I can help you and explain the strategy and the value of IP. I think we'll share my coordinates at the end of the session. Okay, perfect. And also, we represent CIPO internationally. What does it mean? CIPO has ratified a few treaties to help Canadian applicants apply in multiple countries. So far, Canadian can apply simultaneously for patent protection. And coming sooner or later, we also have other treaties such as for trademarks and industrial design. So all this to better protect Canadian in all foreign markets. So some women entrepreneurs, and they're all Canadians, but I'm sure we could find many women entrepreneurs around the world that have been successful in securing their IP. One example that I really like is, and her name escapes me at the moment, but there's a young lady called Anne Mekosinski. She's 19 years old, and through some project with the University of British Columbia, she developed a flashlight that's powered by the heat of the human hand. And Forbes named her with among the Forbes 30 under 30. So that's a Canadian invention. She patented it and very successful, and to a point where she won a first place in her age group at the 2013 Google Science Fair, which is super amazing. So, and what I keep telling my clients is never underestimate the value of the invention you have in mind or what you think. You may say, oh, it's only minor invention, but I've got moms calling me like, I invented this new strap system because my baby is so heavy. I've got back problems. So do you think I can patent it? Well, I cannot tell you if you can, but it's worth now analyzing the situation, and you never know what you have in mind or in between your hands that could be very, very successful on the market. We'll switch to the next slide. So more other female entrepreneurs. You may or may not know, but we have some women entrepreneurs. Their name are Janet and Greta Podletsky, and they found they're the authors of the Looney Spoons. I don't know if it made its way outside Canada, but it's a very successful books for children, apparently. There's an Etsy platform was created by Canadian women right here in Ottawa. Roseanne Williams is a senior VP and president of Starbucks Canada. So very, very important. Elise Allen is the CEO of General Electric Canada. So women make their way up to entrepreneurship and leading global businesses. So there's a place for every woman in this world. And the higher, the better. So back to intellectual property. What is IP? IP is a creation of the mind. And what's important is that if it's in your mind, it's not protectable. It's got to be on a tangible support. You could have a business plan, you could have a new technology, you could have an idea to write a new book that will be the new Harry Potter, but as long as it's in your head, you're not protected. You have to apply for patent, trademarks, industrial design, even copyright, but you have to apply and at least make it public to some extent. We'll see how you can do it. And we like to tell people that what makes them different is their offerings. You may want to invent super new technology, you want to have a new service that you're offering on the market. Those are all protectable by IP. So why should you care about IP? Why IP matters? As I sort of alluded to, it gives you an edge over your competitor. And one example I like to give, and that goes to trademark. If you have a headache, you as a person will prefer one medication over the other. Maybe not because it's cheaper or because it's just because for you it resonates as this is going to cure my headache. Here in Canada, when I go to the drugstore, I select Motrin because Motrin for me means I will not get a headache in 2 hours. It will be cured. But for Claricia, it might be different. For Elena, it might be different. Not because they're better, but because they cure your headache better. So companies will spend tremendous amount of money to get that edge over competitors, to get the new cell phone that you're going to wait in line for 10 hours to get it, because you want to be the first on the market and the stronger and the highest sales on the market. And it helps build your reputation and goodwill. What do I mean by that? Again, you create a new technology, you create a new product, you develop a new service on the market. Well, clients will buy it because they believe in the quality of your product. It could be paper tissue, it could be selling shoes, it could be the brand new cell phone, a new wireless mouse, it could be technology that helps you clean your house faster, cleaner, and who knows what it could be. But by developing product and service of high quality, you build your reputation and you acquire your clientele. And you can also use your IP, especially for startups and young companies, to attract financing. If you watch shows such as Dragon's Den or Shark Tank around the world, financiers will be asking potential project holders, do you have a patent on your technology? Do you have a trademark on your product? Why is that so? If I'm an investor and I want to invest in Claricia's company, I want to make sure she's the only one delivering that product or service. because otherwise what's my advantage in spending thousands of dollars, hundreds of thousands of dollars, if anyone could buy, sell, or manufacture that kind of product or service. So it's to be that edge over competitors. It also helps you achieve your business goals. If, let's say, you're planning to develop a new chain of vegan restaurants, well, by getting a right trademark and in the countries where you want to seek protection, it will help you achieve those business goals by identifying where's your market, where should I seek protection. And again, and at the same time, it helps you secure your market. You have to understand that IP, when you mention patent, trademarks, industrial design, they're national protection. So if you have to seek protection in each of the countries where you're conducting business. And for that, you have to contact all the national offices, or unless there's a mechanism to apply simultaneously. But ultimately, you will have to contact those national offices, including CIPO and other countries in the world. So again, knowing about IP will help you avoid costly mistakes. What do I mean by that? CIPO and other offices around the world offer free databases on patents, trademarks, copyrights, industrial design. What it allows you is to search in those databases to find, let's say you're thinking of a new product, a new technology. Well, searching those databases will help you find, does it exist already? But if it exists, it's not that critical. It helps you to improve on that invention. So it doesn't mean that your idea is gone and you can't use it. Just try to improve whatever exists on the market. And it helps you also to understand what your competitors are doing because they've filed for protection. For example, you can look, if you just search for Apple on the trademark database, you will see what they apply for, what kind of names. Let's say they come up with an iTable application. So you can expect an iTable something on the market in a few months, few years. So by monitoring what your competitors are doing or applying for, you can tell where they're going. So you can realign your strategy to, again, still become better and more powerful than they are. And again, by knowing what they're doing, it helps you focus on your business strategy. And as I say, you can realign, or you can determine that, okay, no one is doing what I want to do or present or develop, so I'm safe. I can go full speed ahead. So what we'll cover in the next few slides is those IP rights. We'll cover trademarks, patents, trade secrets, copyrights, and industrial design. So a trademark. By and large, on a daily basis, we see 1,500 trademarks. Everything that we have that surrounds us is protected by, is a trademark, protected or not. Think of the coffee you drink in the morning. Think of the platform you use to download or to listen to your music. Think of your clothing, your appliances at home, your car. Whatever you drink or you eat is protected by, is a trademark. In Canada, trademark is not mandatory, but we strongly recommend it for different reasons. So clearly a trademark, it could be a logo, a word, a sign, a shape, a sound that makes your product different than the others. So customers recognize your product. Again, you will choose Starbucks coffee over Tim Horton coffees, or whichever coffee brand there is on the market, or you will choose to drive a Toyota instead of a Honda for different reasons. And for Canada, and probably for all other countries in the world, having a trademark is a right to exclude people from using your mark in that country. And it's also a means to make money by, you can grant licenses or franchise on your trademark. Think of all the restaurant or the retail industry. All they do is they grant franchises for people to sell food or a product under that banner. Pardon me. As I said, in Canada, it's a mix of automatic use and registration. What does that mean? It's not mandatory to register your trademark as long as you can determine or confirm a date of start of use in Canada. But it makes your life easier, especially if someone infringes on your trademark, that you have to demonstrate that, okay, I've been using it for 2-3 years and I got it registered. It's easier, pardon me, it's easier like that. In Canada, a trademark is valid for 15 years And the good news is it's renewable every 15 years as long as you use the product or service attached to the trademark. Sorry, I'll just drink some water before I choke completely. Pardon me. And we also recommend that you use your trademark. What does that mean? After the 15 years protection time, if you don't use your trademark, we can refuse renewable. And trust me, it's easy for like very famous marks to control the use or not, but for smaller companies, competitors will monitor the reapplication, and they can invalidate your trademark if they decide that, you know what, you're not using it anymore. Don't pretend you're using it. So you like to clearly demonstrate that you're using your trademark to get it renewed. And something else, you want to make sure that your trademark does not become public domain. What do I mean by that? You might think it's cool that your trademark becomes a common word, but not really, because then you loses the value over your trademark. One example in Canada is paper tissue. The Kleenex brand lost its value and right to be renewed because everybody keeps referring to the product as Kleenex when they're not. So what does that mean is in terms of marketing, people facing a pile of paper tissues will not select Kleenex because it means quality. They will choose the cheapest brand or whatever they want or the cutest box, but not the Kleenex one per se because it just became common use. So it's a balance of using it and making sure it's properly used. Here are some very famous Canadian brands: Shopify, Canada Goose, and Tim Hortons. So some tips when you apply for trademarks, try to invent a term. Kodak was a really good one. Kleenex at the time was a really good one. Of course, it lost its value. Polaroid was one too. Those are really old marks, but Kodak, of course, went bankruptcy, so they're not using it anymore. Or try to use a word that has nothing to do with the good or service that you're selling. Apple for computer. Now we all know Apple. We recognize the logo. But way back when, what actually was funny because they were eating an apple at a meeting, and they said, "Oh, let's call the company Apple," and because it was halfly chewed, so that's what the logo is with the half-chewed apple. Roots is a good one too because nothing will tell you if it's Roots. Oh my God, they're selling clothing. You know, Indigo is another good mark too. Some suggestive marks that are kind of associated, like the chapters bookstores. There's a lot of chapters in a book, but it doesn't. When I see chapters, it doesn't mean, oh, it's a bookstore. Or Whirlpool for washing machine. It's really good. A really good example. We don't recommend personal names because then, and especially by law in Canada, if you want to protect your name as a trademark, I'm not sure if it's the same across the world, but your name, there has to be less than 25 people in Canada to protect the name. So yeah, so someone like me, my name is very common. I could never have a trademark under my name, and it's not recommendable. Daria, my colleague, would be probably able to protect her name as a trademark. And also, we don't recommend descriptive marks. Let's say you're trying to sell you're starting a new business selling apple tarts. Well, you cannot call it sweet apple or sweet tarts because it's too descriptive. Or like John's Burger Shop. Like, no, if John sells burgers, we recommend a much better name that's more attractive. And also in Canada, you can't register what we call injurious words. Or if it's too religious, also you can't protect them. But that examination will determine if it's registrable or not. So what we recommend you is go on our website, on CIPO site, and we'll be sharing the presentation after, ladies. Okay, perfect. So we'll have the links to the different databases. So search our database, and keep in mind also that if the name you have in mind is already registered in Canada, don't panic, because we can have coexisting brands as long as they don't create confusion to the eyes of the consumers. One example is the McDonald's. We have the restaurants in Canada, we have a cigarette manufacturer, and we also have a lawyer's cabinet. Because there's no confusion between the three services, we allow registrations with the three brands. But one example that would never get registered is we have a retail store, they're called Farm Boy. They sell fruits and vegetables, and it's F-A-R-M Boy. Well, if a pharmacist wants to open a chain and call it Farm Boy, P-H-A-R-M, anywhere in Canada, they could not, because it creates confusion to the eyes of consumer. If I tell you, let's meet at Farm Boy, you don't know what I'm referring to. So for that purpose, it would not be registered. Consider distinguishing guises. What it is. Distinguishing guise it's a form, it's a shape of an object that's so recognized on the market that it can become a trademark. One example is the famous Coca-Cola bottle. Anyone in the world recognizes it. So it became a really strong trademark on the market, which means no company around the world could sell beverage in the same shape of bottle. And also consider certification marks, like is it an ISO something? Is it a genuine wool? Is it, and we have a lot, and that includes also the food industry, champagne, camembert, anything that's protected. Pardon me? Yeah, truffles. I mean, and that resonates as a quality, and no one else can manufacture, produce, sell those products unless they're really champagne and everything. And also, I have to tell you about the process. It takes about 12 to 18 months to get registered as a trademark in Canada. What it is you apply, and then your file is assigned to an examiner who will prepare a first report. Most of the time, you will have modifications to do. It could be adjustment, it could be changes in the description, whatever it is. At this point in time, your examiner becomes the reference person. They will tell you exactly what they need to make your trademark application registerable. Ownership is whoever is the owner, the co-person that will be using the mark. And by process, if you sell your company, you sell the product, you have to notify any offices around the world that there's a change in the titles of ownership. In Canada, trademark are not a business name. So some people think they register legally their businesses thinking, oh, my trademark is protected, but it's not. It's two different protection. There's the legal entity, as I said, and there's the branding protection. So trademark is clearly the branding. In Canada, if you see the circled R, it means it's officially registered. If you see the TM, it's not registered. Maybe they never applied for protection, or it's in the process of being registered. Marking is not mandatory in Canada, but because it is in most of the countries around the world, Canadian entrepreneurs will do the marking, so it's easier when it comes to shipping material around the world. So patent. Patent will protect technology, and it's got to meet 3 criteria. It's going to be novel, new to the world, and that's very important. Once there's a disclosure in the world, it might prevent you from getting your patent. Even if it's someone else disclosing the information, it's been disclosed, it's no longer new. It's got to be useful. It's got to solve a problem. It's got to fix something, like those moms with the straps to carry the babies to prevent back problems. That's solving a problem. And again, never underestimate the value of what you have in mind or what you think you've created, because it could become the new thing in town and you can become rich. And pardon me? Exactly, yeah. And the last criteria is the non-obviousness. And this one is the most blurry criterion. What does it mean is that when you apply for patent, might it be a biotech, a computer science, a mechanical engineering invention? For people that are versed in the art, it's got to be non-obvious. So you've got to be able to demonstrate that first, no one thought about it before, and then that it's not by combining the knowledge of, at this point, that you created that new invention. So it's got to be that non-obviousness. Clearly by saying, well, no one thought of it is a non-obviousness factor, but that's where we have to negotiate with patent offices to get your patent granted. And again, it's a right to exclude people from selling, using, and making your invention. But again, you can grant licenses around the world where you sought protection and obtain it, so you can make more money out of your invention. Some entrepreneurs, all they do is they create new technology, they got patent, and then they sell it to larger corporations because they don't have the financial means, nor the support, nor the channels to do it on their own. So that's their business model. Or they will get a license with larger corporation, and then they make the money out of it. One example that I really like, it's one of my favorite, is a small company in Canada that developed a technology that would help you control and monitor energy consumption in your house. So they applied for patent protection in Canada and the States, and they've done the research and they knew Microsoft was interested in that technology. So they called Microsoft and they said, well, we have that technology. It's patent pending. So they got a license agreement, and now they're over 90% of households in North America. So Blue Line Innovations in St. John's, Newfoundland. Yeah. So it doesn't mean that if you're a small player that you can't negotiate with larger corporation. Just make sure that the deal is good for you. And I'm not sure if we'll cover that later, but if not, we can do, but make sure that there's agreements, non-disclosure agreements, that there's reciprocity for both parties. And don't be afraid to negotiate with larger corporations. Just protect yourself accordingly. In Canada, it's up to 20 years. The protection for patent lasts for up to 20 years from the date of filing, not from the date of granting, which makes a big difference. And in Canada, once you apply, you have 5 years to request examination, so it's not automatic. Some industries will prefer to wait till the end of the 5 years for different reasons. Like pharmaceutical will still have to complete testing and get approvals from Health Canada and the FDA in America. But some industries will need to rush it as soon as possible and get the patent granted, like computer technologies, cell phone technologies. And I spoke earlier about novelty, but if there's, in the event that there's a disclosure of your invention, countries like Canada and the States will allow you 12-month grace period, which means you have 1 year to apply. But most of the countries in the world have zero tolerance policy. So you have to make sure that if you have to attend a trade show, if you have to present research results in a conference, make sure you at least file for what we call in Canada incomplete application, or in the States a provisional patent. At least you've got a filing date and you're somehow protected, and you've declared to the world that I'm the inventor, so here's our position myself on the market. Some patent tips. Again, do a prior art search online using our patent database. Sorry, the link is not there, but it's easily accessible on our website. We highly recommend that you hire a patent agent. Filing for patent protection is very complex. It's a different grammar in itself. It's new. It's a different wording, and the prosecution is so difficult and tedious that having a patent agent who's not a lawyer necessarily, but they're specialists in their field, they have, most of the time it's minimum a master degree or PhD postdoc in the field that you're active in. And when it comes to hiring a patent agent, you really have to make your research and hire those that understand your technology, because they will be negotiating in your name with the patent office, with an examiner that's just as highly qualified as the patent agent. You need to have people that understand the technology, that understand the sector, and understand where innovation is going to. So they become expensive, but it's an expertise that as I said, we consider you hire them. And when I spoke about novelty, don't be afraid. It doesn't have to be disruptive technologies. Any improvement on an existing product can be protected by patent, as long as you demonstrate that it's still a significant improvement. And again, by law, a patent does not give you the right to use it. It gives you a right to exclude people. But again, it's your patent. You own it, so you can decide to exploit it yourself. And as the main tip is, do not disclose. Keep it secret. Don't even trust anyone around you. You can tell them, I'm working on something I'm working on a new wireless mouse, but don't tell them exactly how that new wireless mouse will work. It was a new feature. Just say as less as possible, just to attract people and attract some financing. But don't reveal all the details unless you sign non-disclosure agreements. Again, a patent application must include all the names of inventors and co-inventors. Otherwise, we can invalid a patent. And competitors will do their competitive intelligence, and they can invalidate your patent. So what you can do is, before hiring a patent agent, as a patent applicant, you can describe the invention. You're the inventor, so don't hire someone to describe it. It's 1 or 2 paragraphs. And make sure that your invention is really new to the world. So search, don't only search patent databases. Search Google, search the internet. Google your invention, so just to make sure that it's brand new to the world. And then I've explained the non-obviousness, so we can switch to the next slide. So if a patent is a full disclosure of an invention, the opposite is a trade secret. The trade secret is any confidential information that your business holds and that must remain confidential, either for the duration or until you file for patent or industrial design. So what can it be? It could be operational, it could be a know-how, it could be on a product. For instance, the Coca-Cola recipe has been kept secret for over 100 years. We know some ingredients by looking at the can of Coke or the bottle, but no one knows the process to manufacture Coke. And they have tremendous policies on the secret that the access is very limited. They have trucks delivering false fake products to the plant so that people will think, oh my god, they add that to the recipe. So it's just to be counter espionage, industrial espionage. So there's no formal registration for trade secrets. It's legal bounding documents between whoever has access to the secret. And other means could be encrypting information, locking information in a cabinet where no one has access to except for very limited people. And again, never disclose your trade secret, otherwise you lose your advantage. Like going back to Coca-Cola, if by some weird reasons or fashion Coca-Cola recipe gets disclosed to the public, doesn't mean that Coca-Cola will not produce Coca-Cola anymore. It just means that everybody can do it, so they lose their advantage. So as I said, keep it secret. Have non-disclosure or confidentiality agreements with your staff, with your collaborators. And those agreements have to include what are the consequences of disclosing information. The problem is if it's an individual who steals the secret and reveals it to the world, unfortunately, they're not worth a lot. So the damages are way higher than any money that you can get back from that individual. So make sure that you can trust the people that have access to. And it could be anything from, as I said, encryption or having a password protection or a lock and key or any mechanism that is good to protect the secret is good. Just make sure it's reinforced within your company and anyone working with you. Industrial design is the visual or feature of a shape and configuration, an ornament on a finished object. Think of, again, the Coca-Cola bottle. When it was invented back in 1917, they applied for an industrial design, and it became so famous that they could transfer it to a trademark at the end of the protection. In Canada, it lasts for 5 years, renewable once, so maximum of 10 years protection. And this is the right that has the larger variety of, in terms of protection time. States is 14 years. European countries tend to offer 24 years protection. So before you apply in different countries, make sure you're aware as the length of the protection. And again, same as for patents. In Canada and the States will offer a 12-month grace period if there's any disclosure. And disclosure could be as easy as you're studying in a industrial design faculty and there's an exhibition at the end of the year. Companies know and they visit those exhibits and they will steal your ideas. And you find your products or your shape or on the market. Your design is on the market and you lost the rights to it. Because it's first to file as opposed to first to invent. So again, some tips, do some search online to make sure that the design that you have in mind does not exist, is not registered anywhere, that it's new or significantly different from what exists on the market. And again, the main thing is that it's It's all about the look. It's not about functionality. And as I said, you can transfer into a trademark. And okay, so when you apply for industrial design, you have to provide 6 pictures that will cover the design. So the front, the back, the top, the right side, and the left side views of the design. And that's all explained in guides and CIPO's website, so don't worry, you don't have to remember all those details. They're easily accessible. Copyright. Copyright protects our artistic or literary work, such as a play, a choreography, a picture, a business plan, a computer program, a musical, anything that's somehow is creative is protected by copyright. Good news is that it's automatic upon creation. In Canada, it's the life of the author plus 50 years. And when I say and it's around the world, so it's a worldwide protection. All those countries that have ratified the Berne Convention will recognize your copyright. So I don't have the list right at the top of my head, but you can consult the Berne Convention documents and see which countries are covered by that treaty. Oops, whoops. Whoa, okay, whoa, okay, I'm getting there. So some tips. If you apply in Canada at CIPO, it's $50. So it's fairly economic, and it gives you an advantage. Let's say your work is infringed by someone else's. There's plagiarism on your work. If you have that certificate that demonstrates you're the creator, the person copying your work has to demonstrate they could be the potential author. If you don't have that certificate, you have to demonstrate that you're the creator. So the onus is on you. So for $50, you can clearly demonstrate that you're the author. And what you do, if you have a website, any work you do, a business plan, always include the Circle C, the year that you created the work. The author could be yourself or your company's name. And I always suggest to clients to add that all rights protected. So then it says to the world, my work is copyrighted. Don't copy it. And again, going back to one of my first slides, is it's not the idea that you have in mind that's protected, it's how you come up with a concept. So you could decide that you can write a book on a wizard boy in England. That doesn't matter. Just don't call him Harry Potter and don't copy the titles, okay? Because that could be infringing on the copyright of Harry Potter. The author of the work is not necessarily the copyright owner. What do we mean by that? If, as a logo designer, you're hired by a company to design the logo, that company owns the copyright. Although you, as a creator, you own what we call the moral rights, so they cannot modify the logo without your consent. So, as I said, software are protected by copyright. You can try to get a patent on your software, but it's very costly and it may not be worth all the cost, but it's an option that you have also. I like that slide because it sort of gives you an overview of how you can protect different aspects of your product, service, or technology. So if it's an invention, your options are trade secrets and patents. And how do you decide between them? If it's a feature, if it's what we call easily re-engineerable, go for patent. But if it's like agri-food is very big on trade secrets because it's not by drinking Coke or eating a very specific recipe that you can decipher, understand exactly what's the process. So you can go for trade secrets. If your product has a very different design, you can protect by trademarks and at first by industrial design. If you have a brand, a name, a logo, and a shape, it could be a trademark, it could be copyright, it could be industrial design. If you have a visual, literary, and musical creation, that's copyright or trademarks. Think of other derived products from Star Wars, Pixar, Walt Disney. They all became very famous trademarks, very lucrative as well. So never underestimate the potential of the product and service that you have, again. So going into what's an IP strategy, that's a very good definition by one of our incubator in Canada called Mars, located in Toronto. So an IP strategy is a series of decisions and methods designed to maximize the contribution of IP to achieve your business objectives. I like to remind my clients that your business objectives is the ultimate goal. Is like, what do I want to achieve in such a time on all those markets around the world? Well, under that umbrella of business objectives, you have IP strategy, marketing strategy, R&D strategy, HR strategy, name it, and then all those combined together will lead you to achieve your business objectives. And at one point in time, your marketing strategy becomes more important. At some other point, it's your research and development strategy. So you really have to focus on this and put the efforts at the right moment. And chances are IP will be included all the time. So what do you need? To develop your IP strategy, what do you need? You might need to acquire some IP from other companies because you need that brand, you need that patent to help you build your product or service. And you need to create your own IP portfolio. How many trademarks you have, how many patents you have. It really depends, and you have to really monitor. For a very startup and young company with only one patent or two patent pending and one trademark, it's easy to monitor. But companies like Apple or BlackBerry or Microsoft have millions of patents and trademarks, so they have teams dedicated to monitoring the IP portfolio. And again, IP evaluation is how do you align your business strategy and goals, and how do you evaluate the value of your IP? Companies will, and specialists like licensing specialists will help you put a value on your trademark, on your patent, even on your trade secret. In terms of trade secret, what if the trade secret is disclosed? What's the damage made to your company? So that's part of the evaluation too. How will you manage your IP? Will you just keep it to yourself and exploit it on your own, or will you grant licenses? Do you need, or will you sell it, or again, do you need to acquire IP to better help you? And again, that's a very important point. The IP owner is the one responsible for monitoring infringement and plagiarism, counterfeiting. IP offices around the world will not do it. So you have to ensure you have enough people around the world in countries where you sought protection to monitor that IP. And again, it becomes a strategic choice. You might have the coolest technology, the coolest product in the world, but if your network is very small, you may not want to apply for trademark and patents in all the countries in the world. You will select those where you've got clients, where you have manufacturers, distributors, and again, people to monitor. And in other countries, sometimes your distributors or manufacturers will become the monitoring force behind the technology of the product because they have all the advantage in the world to keep it away from infringement and counterfeiting. And enforcing your IP, you have to prevent and remedy any infringement. So do you have the financial means to bring people to court if there's any infringement or counterfeiting? Are you ready for this? And what's your strategy? So those are some questions you can ask yourself. So are you protecting that IP, or do you prefer to leave it unprotected? And I'll give you an example. And the beauty of my role is that I'm not selling IP completely. I'm not under commission, so if I talk to people, they don't have to take a patent or trademark. And there's one example. He was not my client, but there's a young guy in a province in Canada who developed a technology that was purchased by all the coffee shops in North America pretty much. It's called a Sure Shot, and it's what allows them to shoot 2 sugar, 2 milk, or 2 creams, or 1 or 2, depending on. But back in the days, this guy was like super young. He had no money to file for patent, and he knew the value of patents, but he just couldn't afford them. So what he did, he was really big on branding, protecting the trademarks, and positioning himself as the best new technology in the world to better help coffee shops. So they all purchased the technology without having a patent, and they all adopted it. Now that he's making lots of money, he's developing in new technologies and he's been granted patents. But right at first, he consciously decided not to seek for patent protection, but and he built his reputation on the trademark, on the quality of the technology he had. Exactly. So again, how will you be aligning your strategy, your IP strategy, with your business objectives? And also in terms of management, do you know Do you know exactly what the rights you have? Some companies developing multiple technologies will do what we do, a stage gate approach, like, okay, are we sure we're still going on with that technology? Oh no, okay, this one's not that promising, so we'll drop it and we'll focus on something else. Who's monitoring the rights? That's very important. As I said, especially if you're going abroad and you're active in multiple countries, you need to have that network that works for you. And again, are you making sure that you have the means to enforce your IP rights? All things to put into consideration. So some possible IP strategies. You can seek patent protection on technical aspects. And again, if it's not for you, you can have different means. That's where I come into play. I can help you. So if you focus on the brand value, like this guy did with a Sure Shot, he seek trademark protection and he was big on promoting it. You can also file for protection and being very offensive with your objectives. So what you do is you will sue anyone that comes near your patent, your trademark, by counterfeiting or infringing. You can also file protection for defensive purposes. So all you do is your IP rights. So what it does, this one is very interesting because whatever IP rights you have, you will monitor your competitors and you will sue them for anything that if they again come close to your patent. So it might just be a way to make money out of your patent without exactly exploiting it. You can combine IP rights, of course. Think of a cell phone. In a cell phone, there's a plethora of patents, trademarks, industrial design, copyrights, and trade secrets. You can also decide not to file for any protection and make it public domain. Or some companies was IBM a few years ago, they made their green technologies patents available to the world. And Tesla did that recently too. Yeah, exactly. So what it does, companies will do that as a good faith, as a marketing tool. Again, we also have soon to come, what we do webinars and seminars, and on our website you have the calendar of events. So you may want to register to those free webinars. We do them once a month, or pretty much once a month, and we do have seminars, but if you're interested, we can link you by webinars as well. I just did that recently. We're soon to also, we'll have an IP boot camps. They're not organized yet, but for you guys, it may not be the best solution. Or we have search-a-thons. We're teaching people to search our databases. Yeah, those are soon to come. And we do custom training programs such as this one, but one of my colleagues recently did an IP presentation for textile industry. So we can tailor our presentation to a certain sector. So the number here is wrong because it's in the Canada one, but I'll give it to Claricia to send it to participants later. I'm sorry, I forgot to change that. And you're more than welcome if you come to Canada to come and visit us. We're across the river from a trade facilitation office, and we'll be more than welcome to welcome you. We have a Twitter account, French or English, and we have a LinkedIn account as well. And I've just promoted this morning's webinar on my personal account, so you're more than welcome to join me as well. Yeah. We've been asked to be more active on Twitter, which is good because it promotes IP and partnerships on a larger scale. We appreciate that very much. Yes. So that concludes my presentation. Thanks for listening to me, and we'll still some questions come.
First question is related to copyright, and I was wondering because a lot of our exporters are in the processed food sector, is a recipe something that they can file as a copyright or a process to make bread?
Most of the time people keep them as trade secrets, so they don't disclose their recipe. But I would file for copyright because it's $50 versus $15,000.
So I filed a recipe as a copyright, but the process I just keep as a trade.
Yeah, I would just keep it as a trade secret, honestly.
So the best for a recipe is a copyright now.
Like think of the Coca-Cola recipe. It's the name becomes a trademark, but the recipe itself is kept secret. Mm-hmm.
its logo a copyright, a trademark, or both? Because you kind of said, oh, you can file a logo as a copyright and you can also file it as a
I
trademark.
probably didn't. I probably made a mistake, but no, logo is a trademark. However, the design itself could be a copyright from the author, but you can't protect it through a logo by copyright itself. Yeah.
So we have some questions already here.
So we, okay, go ahead.
In the textile industry, how do you protect your bags items? So
The
bags
design.
would be
And the logo again, the brand.
And the logo.
so you protect it both as a
Yeah.
Yeah.
As a trademark.
As
Yeah.
a trademark.
Because if you want to protect a design by copyright, only the first 49 copies will be covered by protection. After that, it's public domain. So we like to protect by initial design.
Thank you so much for that. There's another question here that's quite interesting, and this has to do with this sounds almost like copyright because this is actually creating training manuals. So this person is extremely specific. For someone from the Caribbean wanting to protect their training manuals, what is the first step? National intellectual property office, and then to other markets where it will be used. So in other words, I think they're thinking is the first step their national IP office, and then the markets that they want to export or use this training manual.
It's copyright protection. And because I don't know by heart which countries have ratified the Berne Convention, you'll have to check. But if your country has ratified it, you have to find the right organization that protects it. Like, for instance, in Canada, it's CIPO, but in the States, it's the Library of Congress that protects the copyright. So find the right organization and identify which countries have ratified the Berne Convention. And if you're looking for using those materials in other countries that have not ratified the Berne Convention, consider applying in those specific countries also. But as Berne Convention, I think, covers 156 countries. So chances are your country will be covered by the Berne Convention.
We spoke a lot about copyright. We spoke about trade secrets. We spoke a lot, and I know I noticed that we have Trinidad, we have St. Lucia, we have Jamaica on the line. So Alina, just wait and let me finish, okay? On the line, and I know that we have a lot of culinary and health products that come out of there. So if you have questions around those products, that would be great if you ask them now. All right, thank you. So Alina has here, is industrial design both for shape and color?
It's for the shape. And if you look at the slide that I just put back on the screen, that's a Lululemon Athletica Canada pants. They would apply for that shape, and it's mostly, if I recall correctly, it's the top, it's the belt that was really protected, and you have to apply steeple line. That's what you protect, or it's the opposite. But I'm not a special. You'll have to check. But if you look at our database, you will see, and clearly what's protected is identified clearly. So it could be just a portion of the pants that's protected. Yeah. So and that case, it was the top of the Lululemon pants, the yoga pant. So let's say you're applying for a shape of the Coca-Cola bottle. It's clearly just because in design, it's the shape we're looking at. It's not exactly the colors. But it's funny, and that's me saying so. That's my evaluation of the fact. CIPO is hiring a lot of patent examiners in the field of mechanical engineering because of AI. So what they will protect is, let's say, the new arm that will remove your teeth, you know? So that's a feature that it will be protecting. Yeah. And what I was told from people active in AI field was that what was even not imaginable 6 months ago is now being filed for patent. It goes so fast. Yeah. Absolutely. hmm Oh yes. Mhm. And it. Oh yes. Actually, it's a very good point you're raising because think of the fact that the Patent Act was written back in 1920s, pretty much, where software was very not the big technology item. So just think of a few years ago when Amazon applied to patent protect their one-click thing. Yeah, well, Canada rejected it because by definition, by law, we don't protect software. So what? So CIPO rejected the application and it was granted in the States and in other countries, but the law was not modernized enough so to accept that. So what Amazon did is they counter-appealed the decision. They appealed the decision. CIPO counter-appealed and counter-appealed. So it went up to the federal court. And that's when it was decided that CIPO had to consider software protection as long as there's a business application to it. And there was very few years left to that Amazon one click before they got granted. Yeah. So yeah, so it might be like, I don't know. So yeah, and I think they got it granted in 2012, 2013. So oh yeah, it was very long. Yeah. So coming back to AI, the law is evolving so quickly. Like the field is expanding so quickly and developing. So CIPO and other IP offices around the world will have to evolve to accommodate. So maybe years ago we did roundtables across Canada and people involved in software development were telling us maybe we need something in between a patent and a copyright that doesn't take years to get granted and that's not extremely costly, but just to protect that software more because a copyright protects the code itself but not the functionality. Well, the patent will protect the functionality. So you can copyright your software automatically, but it doesn't prevent anyone from having the same type of functionality, but using the different code. That's a whole subject for another presentation. Yep. hmm Okay. Good question. Okay. So if you file for patent protection on your own in Canada for 20 years, it's $3,000 to $4,000. That's administrative fees because we have yearly maintenance fees. If you hire an agent, consider 10 to 15,000 per country. And keep in mind that we have to translate into the language, official language of the country. So if you apply in Germany, Japan, China, Korea, States, France, it's all different languages. So you add to the cost. And to this day, Google Translate is not good enough to translate your patent application. You need a specialist. If you apply for trademark in Canada, it's $450, $250 when you apply and $200 when it's registered. And a trademark agent, you can add like including administration fees, it's $1,500 to $2,000. Industrial design is, I think it's $700 if you apply on your own, and about the same thing, $1,500 to $2,000 if you are a patent agent, who's the one who will do your industrial design. Mm-hmm.
Caroline, as usual, you come and you deliver a lot of thoughts for us. We have, you know, I hope our exporters are recognizing that, you know, they have options to actually register their different type of intellectual property rights in Canada, but also within their own jurisdiction and other jurisdiction outside of their own home country and Canada. I am really, on behalf of TFO Canada, I really want to say thank you to Carolyn and CIPO team for always being here for us. We encourage you to reach out to her. She has provided her email address and also her Twitter handle. We encourage you to, we'll be sending out the recording in another 2 weeks with the presentation, so that you, 1 to 2 weeks, so that you have this on hand and you can share, trade support institutions can share with their exporters, and everyone else could share with their team. We have, we have on March, sorry. We also want to tell you about our upcoming webinars. On May 17th, 2018, we'll be having a certification webinar. We'll have the Executive Director of Fair Trade Canada and a representative from Rainforest Alliance, who will be, we'll have a panel discussion around the value of certifications, the challenges and the opportunities, and we hope that you will go online at tfocanada.ca/webinars and register for that seminar, actually webinar, but it's more of a panel discussion. So we'll have an opportunity to ask questions to the panelists, and we're looking forward to that because that's a new way that we'll be doing our webinars. So today we thank Carolyn and team again, and thank them for even the past for that amazing 5-series intellectual property 5 webinar series that's on our website. And we thank you, our exporters and trade support institutions, for being a part of today's webinar, and look forward to seeing you either in Canada for a trade event, or when our other project managers go abroad to on trade missions. Thank you and have a great day.
Thank you all.